Welcome to the Orchid Advisor's Compliance Training Series, Export Controls, Due Diligence, Know Your Customer. In this video, we examine the recommended steps for conducting due diligence on the prospective customer and end use of the international sale of your product. Why is due diligence necessary? In any sales transaction, and especially those involving a foreign customer or destination, it is imperative to know who the customer is and the reason they are buying your product. The government holds exporters responsible for conducting adequate due diligence and for detecting potential risk for diversion or unlawful use whenever possible. Consequently, for every export, the exporter must be able to answer the following questions with certainty. These questions address the basics of a prospective transaction. What is the item or information the customer wants? Where is it going, the ultimate or final destination, and how? Who will receive it and who will touch the transaction or product? How will the customer use the product? Why does the customer need the product, and what else do they do? Any doubt or question should be resolved as early as possible with additional due diligence if necessary. Every U.S. company has an affirmative legal obligation to determine if any party with which it is about to conduct business is a prohibited entity. This is because conducting any business with any prohibited entity or individual is strictly prohibited, including disclosure of controlled technical data. A rule of thumb should be check early and often. Never assume validity or bona fides of a particular party. So, who should be screened? In a nutshell, anyone involved in a transaction, regardless of whether that person will actually touch the goods. This means employees, distributors, joint venture partners, letter of credit transactions, including intermediary or advising banks, freight forwarders, brokers, customers, purchasers, and/or end users, shipping lines and insurers, marketing agents and consultants. How do you screen? Consider checking the following resources. Internet. Does the customer have an established web page? What is the status of the copyright? Local government offices and U.S. embassies. Reputation in industry. Dun & Bradstreet, dnb.com. Actual site visit when possible. An essential but not exclusive part of the screening process is to check all parties against the various lists the U.S. government maintains of debarred and prohibited parties. There are several lists, each of which is managed by the Departments of Commerce, State, or Treasury, pursuant to their authority under specific statutes. A hit requires additional due diligence before proceeding with the transaction. If you conclude a party to your transaction is indeed listed on any of these lists, it may mean a strict prohibition. We recommend visiting the website export.gov for more information on these lists. This website also contains a consolidated screening list, which may make it easier to conduct party screening compared to screening each individual list. Always confirm basic facts of transaction, including the delivery point, who will take possession, what is the end use, whether the customer is the final end user or selling or distributing the product to other parties. If the customer is an intermediary distributor, to whom do they sell and where? It is important to educate your foreign and domestic partners so that they may also be on the lookout for warning flags. Some examples of red flags, taken from Commerce Department. The customer or purchasing agent is reluctant to offer information about the end use of a product. The product's capabilities do not fit the buyer's line of business. The product ordered is incompatible with the technical level of the country to which product is being shipped. The customer has little or no business background. The customer is willing to pay cash for a very expensive item when the terms of the sale call for financing. The customer is unfamiliar with the product's performance characteristics, but still wants the product. The customer declines routine installation, training, or maintenance services. Delivery dates are vague, or deliveries are planned for out-of-the-way destinations. Freight forwarding firm is listed as final destination. The shipping route is abnormal for product and destination. The packaging is inconsistent with stated method of shipment or destination. The buyer, evasive or unclear on whether product is for domestic use, export, or re-export. Good business requires due diligence, and ignorance is not bliss. The government pursues very aggressively instances where there appears to be purposeful avoidance of actual knowledge or willful blindness on the part of the U.S. exporter. It is therefore important to have a firm understanding and awareness of all parties involved in the transaction, and to identify and resolve warning flags before the export license application is submitted to the Department of State. Failure to identify and resolve red flags before submitting applications will result in removal of parties from license, a return of a license without action, outright denial, or perhaps even a blue lantern, which is the State Department program for investigating and confirming end use and end users. Unfavorable blue lanterns can have negative consequences. For example, closer scrutiny on future license applications and the negative impact on the corporate reputation, to name just a few. Thank you for watching this segment of our video training series. Viewers are encouraged to seek professional advice prior to assessment, implementation, or execution.